So for example, we have a company known as Mumias. So this is Mumias Sugar. And we have this particular creditor known as Kenya Commercial Bank. So if under the agreement of lending money by Kenya Commercial Bank to Mumias Sugar, they were actually allowed to be able to appoint a receiver in case of default in payments. It simply means that if Mumias Sugar actually defaults on payments, Kenya Commercial Bank as a creditor or as a lender is entitled under the agreement to appoint a receiver. When the receiver is actually appointed, automatically, the directors of the company known as Mumias Sugar will automatically lose their positions. And of course, the receiver will take over the operations or management of this particular company for the benefit of the creditor. Alternatively, this creditor can actually be able to come in and take over the specific assets in the company which were charged or were used as a security for the benefit of Kenya Commercial Bank. So KCB lent money to this particular company on condition they provide security or charges. And of course, if they default on payments, they can appoint a receiver to take over the management or operations of the company for the benefit of KCB to be able to recover their money from this company. So that's why we are saying a company will be put under receivership in case a person known as a receiver is appointed to take over operations or management of the company for the benefit of a creditor or for the benefit of all the creditors of the company. So if you remember very well, for example, when you are looking at the topic of debt capital, whereby we have a debenture holder as a creditor, we said debenture holders will charge the assets of the company. And one of the remedies they have, one of the rights they have in the company is appointment of a receiver. If you can remember that point very well, one of the rights that a debenture holder has in the company is to appoint a receiver. Now you can understand what the receiver will come to do. The receiver will basically come to take over the management of the company for the benefit of the debenture holder. Why is it for the benefit of the debenture holder? Because if this receiver is actually appointed, maybe this company was being mismanaged. And of course, you know, it has been mismanaged for a number of years. So in case this receiver is actually appointed and these guys, directors, lose their positions, basically, maybe this company can come back to profitability. And of course, it can be able to meet its obligations in terms of being able to pay the loan. So it will be for the benefit of the creditor that the company comes back on track. And of course, it is able to meet its obligations and able to pay the loan to Kenya Commercial Bank. So a company will be seen to have been put under receivership if a person known as a receiver is appointed to take over operations of the company for the benefit of a creditor. So that's what we mean by receivership. So basically, receivership is actually seen as one of the ways of actually avoiding liquidation. Because if this receivership does not actually work, for example, in the case of Mumias Sugar, what this guy can actually be able to recommend, this receiver, he can recommend that the company be liquidated. So basically, it will come, administration of the company or receivership will basically come just before the liquidation. If it works out, basically, it simply means that that particular company can maybe be returned back to the directors, or this receiver can actually be able to recommend that this company be liquidated. So the two major parties who can actually be able to appoint a receiver is actually creditors or actually the court. A creditor basically will appoint a receiver to maybe come and take over operations, or alternatively, take over the specific asset which had been charged. For example, in this case, if this creditor had charged, for example, the buildings of the company, the receiver appointed by that particular creditor will simply come in to seize the building and maybe sell it off, recover the money on behalf of the creditor. A receiver appointed by the courts, this simply means that the creditors have gone to the courts. They have basically asked for the company to be put under receivership, and therefore a receiver appointed by the court will act for the benefit of all the creditors of the company. So apart from these particular two parties, certain statutes or certain acts of parliament have given power or mandate to certain bodies to be able to appoint a receiver. So the best example we can actually be able to give at this particular point is that the Central Bank of Kenya Act gives the mandate to CBK Bank to be able to appoint a receiver in the case of banks, in case basically they are not actually operating as per the requirements of that particular act. The best example we can actually be able to give, the most recent one that was actually very famous, is that Chase Bank of Kenya was put under receivership by the Central Bank of Kenya. So the receiver was actually Kenya Depositors Insurance Corporation. So that particular bank was actually put under receivership. So they put that bank under receivership, under a receiver known as Kenya Depositors Insurance Corporation. But of course, this particular body didn't have expertise or basically knowledge of how to be able to manage banks. So therefore, they appointed a receiver manager. The receiver manager for Chase Bank was Kenya Commercial Bank. So this particular bank actually managed that Chase Bank until when basically an investor came in known as Standard Bank of Mauritius, and of course SBM acquired Chase Bank, and nowadays all the banks that are actually under Chase Bank are now basically branded Standard Bank of Mauritius. So basically what actually happened in this case, this particular receiver basically tried to manage Chase Bank, and of course if it wouldn't have actually basically worked out, it basically means that this particular receiver would have recommended Chase Bank actually be liquidated. So other banks previously have been liquidated. For example, Imperial Bank of Kenya was put under receivership, and of course in such a case it couldn't come back to track, and it was actually liquidated. There's another bank known as Dubai Bank. It was actually also put under receivership by Central Bank of Kenya. So that one also was actually liquidated. But for Chase Bank, lucky enough for them, there was an investor who came in, acquired the bank, and of course it basically remained in operation. That is what we mean by receivership. So we've said the parties who can appoint a receiver in the company is creditors, the courts, and of course certain statutes or certain acts of parliament have given power or mandate to certain bodies the right to be able to appoint a receiver. The best example is Central Bank of Kenya Act gives CBK or Central Bank of Kenya to appoint a receiver in the case of banks. So for example, under Chase Bank, what was discovered that is that the top management or directors were basically acquiring loans from the bank without any form of security. So it means depositors' money was actually not safe, because the money you give the bank, that money that basically is actually in your bank account, is not actually there in real terms. It has basically been given to other parties in terms of loans. So they basically just give out loans and of course take deposits. So since there was actually a rumor that that particular bank was actually going to go under, so there were panic withdrawals. So due to panic withdrawals, basically it means that the company, that particular bank, didn't have enough money. So it ended up actually being liquidated, basically being put under receivership. So that's what we mean by a receiver and receivership. So it can be appointed by three parties. So of course they could ask who the other parties, so creditors, the court, or maybe certain bodies as allowed under certain statutes. So what are the advantages of receivership? What are the advantages of receivership? What are the advantages of receivership? So the advantage of receivership. So in this case, this receiver will be able to secure or safeguard the assets of the company. So that is actually one advantage. Once this receiver is actually appointed, he'll basically come in and of course safeguard the assets of the company. So basically they secure the assets of the company for the benefit of the creditors. So another advantage is that this particular receiver will actually be able to maybe sell off the assets and of course recover the money on behalf of the creditors. So that is an advantage that will basically arise out of that. Also, this particular receiver can actually be able to take over the operations and ensure efficient operations and management of the company, such that if the company was making losses, it can come back to track and actually become maybe very profitable or a very stable company. So that is actually also an advantage of having to appoint a receiver. It has also disadvantages. So putting a company under receivership basically dents the image of the company. It dents the, you're saying?
You are too fast. Too fast.
I'm too fast.
Yeah.
You are taking notes.
Yes, I was taking notes on advantages of receivership.
Advantages of receivership.
Yes.
Okay, it's okay. Maybe I can read them for you again. But of course, these advantages are actually in your notes. Do you have the notes I sent?
Yes, I have.
Yes, they are just there. Maybe you can just take short notes, but these advantages are there. What is a receiver is there. In fact, they are just, those notes are just flowing the way I'm going, like here. No difference at all. But of course, I can repeat. The first advantage, the receiver will secure the assets of the company, for the benefit of the creditors. The receiver will secure the assets of the company for the benefit of the creditors. The receiver will secure the assets of the company for the benefit of the creditors. The receiver will secure the assets of the company for the benefit of the creditors. Number two, the receiver will dispose of the assets, will sell off the assets. The receiver will sell off the assets, The receiver will sell off the assets and recover the due amount, on behalf of the creditor, on behalf of the creditor. The receiver will sell off the assets and recover the due amount on behalf of the creditor. Number three, the receiver will take over operations and management of the company. The receiver will take over operations and management of the company. The receiver will take over operations and management of the company. The receiver will take over operations and management of the company. So when the receiver is actually appointed, the directors will lose their positions. So they'll no longer be there. Automatically, they lose their positions. So now the person will basically have a say in the company is the receiver. But of course, the employees will be retained for the beneficial receivership of the company. So the employees at Chase Bank were actually retained when the bank was actually under receivership. So the directors are the ones who will only lose their positions. Also, the employees can lose, but of course, them sometimes they can be retained for the beneficial receivership of the company, Disadvantages. So disadvantages. So disadvantage number one, receivership hampers the image of the company, or basically dents the image of the company. Receivership hampers the image of the company or dents the image of the company. And several stakeholders will not want to associate with a company under receivership. So what we mean by this, for example, if we had suppliers and they hear the company is under receivership, they will no longer supply to you. If you had customers, if you had several customers, they'll start basically withdrawing their interest from your company. So if Chase Bank is under receivership, it simply means that all the customers are probably going to come in and withdraw their money. So receivership dents or basically hampers the image of the company, and several stakeholders may fail to associate with the company. So even if you are supplying products there, basically, you know, if I supply, probably I won't be paid. So several people wouldn't want to associate with a company under a receivership. So that is a disadvantage number one. Disadvantage number two, sometimes receivers lack expertise or knowledge of how to manage the company. So there's usually sometimes lack of expertise and knowledge of how to manage the company. So lack of expertise and knowledge of how to manage the company. So that is a disadvantage. Lack of expertise and knowledge of how to manage the company. Lack of expertise and knowledge of how to manage the company. So in this case, for example, as I've told you, CBK appoints Kenya Depositors Insurance Corporation. They don't have expertise of how to manage a bank. So this particular receiver actually appoints a receiver manager. KCB, Kenya Commercial Bank, is actually an expert or basically a player in that particular industry. So they know how to manage a bank. So for them, these ones, they lack expertise, they have to appoint a receiver manager. So sometimes there's usually lack of expertise, and of course, receivers are forced to appoint receiver managers. So such a case, that is another disadvantage. Probably probably if you are basically going to sell off the assets as a receiver during that particular point, or when the company is under receivership, you won't basically fetch the market value of the assets, because people will basically know that this particular company is under desperation. So even if you ask for bids, people will basically quote prices which are not actually basically the market value of that asset. If, for example, it was actually a building that you're supposed to sell at maybe 2 billion, you'll end up selling at maybe 1.5 billion as a receiver. So the market value of the asset is likely not to be realized when the company is actually under receivership. So that is a disadvantage. So the assets being sold off by the receiver are likely not to fetch the market value. So are likely not to fetch the market value if the company is under receivership. So because they know the company is desperate. So the assets being sold by the receiver are likely not to fetch the market value when the company is under receivership. The assets sold by the receiver, assets sold by the receiver are likely not to fetch the market value, when the company is under receivership. So they are likely not to fetch the market value when the company is actually under receivership. So people will basically know the company is desperate. So even if the building is, they do the evaluation and they realize that the building is supposed to be sold at a market value of 2 billion. So they won't sell it at that particular 2 billion because they know the company is under desperation. They want to sell the asset. So probably they'll fetch a lower value. The assets lose value, and they won't be able to realize the market value when the assets are being sold when the company is actually under receivership. So those are some of the disadvantages of basically appointing a receiver, was actually putting a receiver, putting a company under receivership. So the role of, or the duties of a receiver.
One more question.
You can ask.
Now, this issue of managers losing their job, can
Yes.
it be one of the disadvantages under receivership?
It depends with how you look at it, from what perspective. Basically, from the perspective of the other stakeholders in the company, like employees, it is a disadvantage. So basically, maybe it means how you frame the answer. So it is a disadvantage to them as the stakeholders of the company, like employees. They lose their positions, or they basically lose their job. So it's a disadvantage to them. So it depends basically from what perspective you are looking at it. So to them, as employees of the company, it is a disadvantage. It is a disadvantage to them. So they lose their jobs. But of course, in certain circumstances, for example, in this case, when you look at, for example, Chase Bank. So Chase Bank, you are being told that the directors were basically taking loans without any form of security. So it means the money of the depositors was not actually very safe. Because if you take a loan from the bank and the bank does not realize that money, your money as a depositor might actually get lost. Because what happens when you put the money in the bank, they basically give it out as loans. So that bank balance you have there in the account is not really there. The money has actually basically been put out as loans, so like that. So they issue loans as they get other deposits like that. So it's like money is just rotating in cycles. So it means that this money you've deposited in the account, if they give it out as a loan, it must have a security. Because if it is given out without any form of security and the bank fails to recover it, you might lose your money because you won't be able to get the money in the bank when it is put under receivership. So it simply means that if directors of the company, this particular company are calling Chase Bank, are getting loans from this particular bank without any form of security. So in this case, when even they appoint a receiver, KDIC, and they lose their positions, so utawahurumia watu kama hao, because basically it simply means that they are not basically running the operations of the company as per the requirements of the Central Bank of Kenya Act. Huwezi hurumia watu kama hao kwa sababu pesa yako kama depositor itapotea kama wanachukua loans kwa kampuni bila any form of security. Because it simply means that if you can't recover your money from the loanee, or basically the person you've lent to money, you can only be assured the money will come back if he gives you, for example, a title deed or he gives you, for example, a logbook. So in such a case, for like directors of Chase Bank, what come out, wezi wa hurumia, even though it can be a disadvantage to them, so you can't have mercy for them because they don't have mercy for the depositors of the bank. So that's what we are saying. When the receiver is appointed, the past persons to be targeted, because most probably the company has been put under receivership because it is not actually operating efficiently or properly. It is not making profits. And maybe it is due to mismanagement. So most of these particular companies, you'll hear they have been put under receivership. It is mismanagement, like Mumia's Sugar, mismanagement. So the company ends up not actually remaining afloat to be able to meet its obligations. So most of them, you realize basically it is just due to mismanagement. Even Imperial Bank of Kenya, it was due to mismanagement by the directors of the company. So as a result of that, the company ends up being put under receivership. And of course, the past persons who are targeted are directors. Automatically, they lose their positions when a receiver is actually appointed. But the employees, we've said, they can be retained for the beneficial receivership of the company. So they might stay there for quite some time. So as the company is actually still under receivership. So that basically at the end of it all, when the receiver sees that this particular company is performing so well, they'll basically be able to return it to. Actually, that is what will happen. If it is a successful receivership, the company is returned back. It is given back to the directors. If it is a failed receivership, basically the company will be liquidated. So that's why basically that is what you need to discover under termination of receivership. If it is a successful receivership, the company basically will go back to the directors to continue to manage the company. If it is a failed receivership, the receiver will actually recommend the company's life comes to an end. It comes to an end. That is basically what you need to understand with regard to termination of receivership. So when we say the company is actually now being put under receivership, it's like now the company is actually, it's quite sickly. So they are trying to save the life of the company. It's quite sickly. They are trying to save the life of the company. So they have really tried trying to help this particular company, but it's not actually working. So it is very difficult for the company to basically be put back on track. So basically what is normally recommended is that this particular company be liquidated or its life comes to an end. So that is what will actually happen with regard to receivership. So if it is successful, it is be given back to the directors or basically to continue to operate. If it is unsuccessful, the receiver will recommend or basically give a report to the person who actually appointed that particular receiver. Maybe could actually be the court. It could actually be the creditors. So you basically just recommend the company be liquidated. So the roles and duties of the receiver. So some of them have just come across as we are looking at the advantages and disadvantages and the definition. So part of them include, for example, number one, secure the assets of the company for the benefit of creditors. So that is our role. So secure the assets of the company for the benefits. Secure the assets of the company. Secure the assets of the company for the benefit of the creditors. Number two, sell off the assets of the company and realize the money for the creditors. Sell off the assets of the company and realize the money. Sell off the assets of the company and realize the money for creditors. Sell off the assets of the company and realize the money for the creditors. The next one you can write, pay off as much debt as possible. So you should actually be able to pay off all the liabilities that are basically in the company. So pay off as much debt as possible. Pay off as much debt as possible in the company. Pay off as much debt as possible in the company. So termination, as I've told you, receivership will come to an end basically, maybe by having a recommendation that the company be given back to the directors, or basically there could be a recommendation that the life of the company comes to an end. So if it is not working, so the receivership is not actually working, the receiver will recommend the company be liquidated. If it is actually a successful receivership, the company will be given back to the directors to continue to manage the company. So that means it was actually a very successful receivership. So if it won't work, there will be the recommendation by the receiver in his report that the company be liquidated. If it is a successful receivership, the company will actually be given back to the directors of the company to continue to manage it. So you can look at liquidation of the company.
I have a question, Malim.
Yes, you can ask.
Can you say receivership is also the same as corporate insolvency?
Corporate insolvency?
Yes.
It's the same. Basically, the receivership of a company, what you can say, receivership of a company is actually guided by the Corporate Insolvency Act. So it's the same as insolvency. Basically, the procedures of how a company will be put under insolvency. So insolvency simply means it's not actually able to meet its obligations or pay off its liabilities. So that's what it means by being insolvent. So umesota, you are insolvent. If you are solvent, the other way is solvent, you have enough money to meet your obligations. Insolvent, you don't have enough resources to meet your obligations. You'll basically be declared to be insolvent and actually be put under receivership or administration, such that if that administration actually works, it will be for the betterment of the company. If it won't work, so the other way around, you will see that the company basically will end its life and basically pay off all its liabilities, and they close shop and the company is dissolved at the registrar's office. So it is the same. So it's the same as insolvency. It's almost the same as insolvency. Yes.
Me?
Okay.
What about the statutory management and receivership?
What about
statutory management?
Statutory
management.
I can't get you clearly.
I'm saying statutory management.
Statutory management.
Yes, and receivership. What's the difference?
Statutory management and receivership.
Yes.
Statutory management. So that one I think I need to find out. Statutory management. So I need to find out what you mean by statutory management. But what I just know is that receivership and liquidation is basically guided by the Corporate Insolvency Act. So that particular act is whereby you'll get all the procedures that will be followed in case the company is put under receivership, administration, or liquidation. But statutory management, I need to find out.
For example, there's a SACCO which was put under statutory management.
Which company was that?
A SACCO. Which SACCO is that? There was a SACCO which was put under statutory management because of mismanagement. So that's why I was asking between statutory management and liquidation. Is it the same? Statutory management, meaning the regulator was put to manage the SACCO for a while before the regulator could recommend for liquidation or take it back to the board.
Yeah, it's just almost a similar point you are talking about, the receivership of a company. So like in that case, you could find that maybe under the SACCOs Act, that particular regulator has been given the right. Just like the same case you are talking about under the Central Bank of Kenya Act, they have been given the right to appoint a receiver in the case of banks. So you realize that, for example, in that case, under the SACCOs Act, the regulator, or maybe the regulator of SACCOs, has been given the mandate to be able to appoint, for example, a statutory manager to manage, for example, a SACCO if basically the money of the depositors is not actually quite safe. If basically there is mismanagement of the funds that are being deposited by the SACCO members. So it is just the same, it's almost the same like receivership. But now receivership is basically for the companies being regulated under the Companies Act. For in that case, I think it is almost similar. It's just the same. Because in that case, to what you've described, is that that SACCO was actually put under statutory management. So what I'm discovering from what you've just told us is that, for example, in that case, you realize the SACCOs Act has given, for example, the regulator of SACCOs the mandate to be able to appoint a statutory manager in case the SACCO is actually found out to be flouting the requirements under the SACCOs Act. For example, in this case, the money given by the SACCO members is actually supposed to be safeguarded. If it's not actually safeguarded, basically it means that you as SACCO members, you might come up or wake up one day and find your money is not actually there. So if they discover, the regulator discovers that this money, it is not actually being managed properly by those who have been given the mandate, for example, the directors or basically the managers at the SACCO. So they are basically supposed to come in and, of course, given that they are given the right under the law, under the SACCOs Act, so they are actually able to appoint a statutory manager. So a statutory manager. That's why I told you, not only we can have, for example, the creditors and, for example, the court appointing. Under certain statutes, certain bodies have been given the right to appoint a receiver. So like in that case, you basically find that, for example, the SACCOs Act has given basically the regulator in that particular industry to appoint a receiver, for example, a statutory manager to manage the affairs of that particular SACCO.
I'm reading it somewhere, the meaning of statutory management.
Yes.
Saying it's a procedure whereby the Commission takes immediate control and management of the SACCO's business and assets and may operate the SACCOs until the Commission permits it to resume business on its own, subject to any terms and conditions that the Commission may impose.
They've just gone up to that particular point.
Yeah.
Yeah, but of course, I think you've gotten my point.
Yeah.
You've gotten my point.
There's a question in November 2015.
Yes, you can.
Which is saying, explain 4 contents of the official receiver report.
4 contents of?
Official receiver report.
Official receiver report.
Yes.
So basically what will be found in that particular report is basically what the receiver can actually be able to for example, report in that particular report, because you've seen what, when the receiver comes in, for example, he takes over the assets and of course manages the affairs of the company. We've seen that, for example, he pays off all the debts that are supposed to be paid off and all the liabilities that are supposed to be paid off. So in this case, part of the contents that will be found in an official receiver's report, the official receiver's report will basically be an account. So for example, an account of all the assets and liabilities of the company, all the assets and liabilities of the company, all the assets and liabilities of the company. Another thing that will be found there, how much debt has been paid off, so far, up to the issuance of the report, up to the issuance of the report, up to the issuance of the report, up to the issuance of the report. What else could be there is how far the affairs of the company, have been managed. Then you can have recommendations of the receiver, on the going concern, recommendations of the receiver on the going concern of the company, So in this case, for example, we could say e.g. whether to be liquidated or not. So the recommendations of the receiver on the going concern, whether the company is likely to exist for the foreseeable future or not, as to according what he has actually been able to assess while he was actually the receiver, the official receiver of the company. He was actually the official receiver of the company. So account of all assets and liabilities of the company. So basically the state of affairs in terms of what are the assets in existence, what are the liabilities that have actually been able to be listed. So how many creditors do you have? How many expenses are actually due for payment, which have not been paid by the company? So how much debt he has actually been able to pay off, so far as up to that particular point, the report is actually being given. So maybe there are certain expenses he has been able to pay, for example, taxes to government, which were due. Maybe he has been able to settle them. Then how far the affairs of the company have been managed or carried on. For example, how has he actually been able to carry on the operations of the company in terms of, for example, the affairs of the employees. Has he actually been able to maybe retain the employees, or he has sent off some of them? Are they still actually in existence? Does he actually still need these particular employees? His recommendations as to whether the company is actually a going concern or not, whether it can be liquidated or basically it can still remain in existence for maybe some time, or it's actually on the road to recovery or not. So that will be part of the contents that will be given in that particular report that is supposed to be given by this particular receiver at the end of maybe a receivership. So maybe like after a year, he has to give a report to the key stakeholders who maybe actually appointed him, like for example, the creditors, or maybe the courts, or maybe in this case, that body that actually appointed him, like let's say, for example, the Central Bank of Kenya, the Central Bank of Kenya. So I think we can look at liquidation of the company. So we're going to see what is liquidation. What is liquidation? Dissolution of the company, dissolution of the company. Then we're going to look at the types of liquidation, the types of liquidation. In this case, we look at compulsory liquidation, or it's sometimes known as liquidation by the court. Liquidation by the court. So here we'll see reasons. We look at the reasons why we can have compulsory liquidation, reasons. The petitioners for compulsory liquidation, petitioners for compulsory liquidation, petitioners for compulsory liquidation. Who can petition for compulsory liquidation? Petitioners for compulsory liquidation. Then we'll see the appointment of a liquidator, appointments of a liquidator after the liquidation order, after the liquidation. So we've said we have number one, it is known as compulsory liquidation. Under this one, we'll see reasons as to why the company can be compulsorily liquidated. Then we'll see who can petition the courts, the petitioners for compulsory liquidation. Then we'll see the appointment of a liquidator after the liquidation order by the courts. After the liquidation order by the courts. So what normally follows after that liquidation order has been given by the courts. Then we look at another type of liquidation. It is known as voluntary liquidation. Voluntary liquidation. Under this one, we have two. So you can put A, by members, how it happens, by members. Then B, by creditors, by creditors. So by members, then by creditors. So this is what we are going to learn under liquidation. So liquidation. So what is liquidation? Dissolution of a company. Types of liquidation. So there are two major ones. So compulsory liquidation. Sometimes it is known as liquidation by the court. Then we have voluntary liquidation. Under this one, we have, it happens in two ways. It can either be by members voluntarily or by creditors voluntarily. So, so since we discovered that a company is an artificial person, so when we are looking at the characteristics of a company, we say one of the major characteristics that a company is an artificial person. It is a man-made person. A company comes into existence through a process known as incorporation. So it will actually be formed by a human being. So it does not actually just come from anywhere. So it is usually formed artificially. So also the same way, the company does not actually die a natural death. So like a human being. So there's normally a process that is actually followed before the life of the company actually comes to an end. That process is known as liquidation. It is simply the process under which the life of the company will come to an end. So it doesn't actually come to an end abruptly. It is a process. Just the same way formation is a process, the same way ending of a life of a company is a process. That process is known as liquidation. So in summary, what will happen during liquidation, what happens in this case, there's usually a key person or a key party known as a liquidator. So this liquidator, basically what he does, he basically lists down all the liabilities of the company, creditors, expenses, and actually pays them according to priority. Basically, if there remains any residue out after the payment of the liabilities, the remaining amount, the whole of it, will be shared among the owners or members or shareholders of the company. If there is nothing that actually remains, it simply means that they'll come out empty-handed. So basically, that is what actually happens in summary during that process. The key stakeholders who are basically really safeguarded during that particular key moment are usually creditors. So they'll be listed, and of course, they'll basically utilize the assets. That is what the liquidator is doing, utilizing the assets of the company and paying them off those particular liabilities. In this case, we're talking about, for example, suppliers who had not actually been paid their money, debenture holders, any form of creditors, and all liabilities in terms of expenses are usually basically prioritized. So according to basically their priority, or basically how they can be prioritized, basically they'll be prioritized and they'll be paid according to that particular order. For example, in this case, the secured creditors, the ones who have securities in the company, they'll be given real priorities. They'll be paid first before the unsecured. Unsecured basically simply means that they basically lent money to the company, or basically there is some amount being owed by the company to them, but there's no any form of security in the company they can actually basically rely on to recover their money. So they'll basically come after secured. Also, government taxes are usually given priority. Then, of course, also liquidation expenses are given priority. So after they paid all of them, then, of course, they now come to the shareholders of the company. They'll start now, for example, in this case, now start categorizing. Preference shareholders, they're given priority. Then after that, they come to ordinary shareholders. So they'll be paid as the last persons on the residues remaining after the liquidation process. So that's why we normally say for preference shareholders, they are given preferential treatment. Even during liquidation, they'll be given priority. They'll be given priority. They'll be given priority. They'll be given priority. So that is basically in a nutshell what actually happens during liquidation. So basically when we talk about liquidation, is the process under which the life of the company will come to an end, or how the life of the company will actually be ended. So after that particular process of ending the life of the company, after all that I've said actually happens, they have been able to pay off all those things, what will happen? The company will be dissolved. So dissolution is basically whereby now the name of the company is removed from the register at the registrar's office. In this case, for example, now if you go to do a search after that, you won't find the name of the company because it has completely been dissolved. Remember, when you are registering the company initially on formation, your name of your company was actually entered in the register at the registrar's office, such that even if a person does and search online, he's actually able to get that particular company that is actually in existence. But of course, after liquidation, when the life of the company has come to an end, there is normally a liquidation report at the end of it all. It is normally deposited with the registrar of companies. So what happens in this case, the registrar, once he gets that particular report and is actually okay with it, he'll simply dissolve the company. So the company won't actually be in existence anymore, even at the registrar's office. So even if you are to do a search to search that particular company, whether it is actually in existence, after dissolution, you can't find the name. So remember, when the company is actually under liquidation, it is still recognized as a person under the law. You can even still sue the company because it is actually still in existence. Just that there's the liquidation process. The process of ending the life of the company is going on until when it's actually dissolved from the register at the registrar's office. That's when it is actually no longer a separate legal entity, or is actually no longer a person under the law. You can't sue it, or it can't even sue any other person for its own benefit. So just know that when the company is actually under liquidation, it is still being recognized as a person under the law. It can be sued. It can actually also sue any other party. For example, if there's any person who has actually wronged the company. But once the process has been ended, the liquidation report has been submitted to the registrar's office, the registrar will simply dissolve the company, or basically remove the name of the company from the register at the registrar's office. So after that, basically the company does not actually exist anymore. It is not actually a person under the, it has actually basically now died. The life has come to an end. So after dissolution. So that's what we mean by dissolution. So maybe they could distinguish between liquidation and dissolution of the company. So dissolution comes at the tail end after the liquidation of the company, whereby the liquidation report is submitted to the registrar. And what actually happens with regard to the dissolution, the registrar removes the name of the company from the register at the registrar's office. So after that, basically the company won't be seen as being a person under the law. So there are usually two major types of liquidation. So you have what we call compulsory liquidation, or liquidation by the courts. Then we have voluntary liquidation, or liquidation by either by members or by creditors. So this one actually happens in two ways. It can either be by members or by creditors. It can either be by members or by creditors. So as from the word just compulsory, in this case, the company is like being forced. It is going to end its life by force. Just from the word voluntary, the company is voluntarily inajitakia yenyewe ku end its life. So it just basically wants to end its life voluntarily. But in this case, the company has been forced. It has no option. So, but someone has actually basically maybe come to the courts. He basically wants the company to end its life. So of course, what normally happens, what starts this process of compulsory liquidation or liquidation by the court, there has to be a petitioner at the court. So he goes to the court, and of course he brings the reasons as to why he wants the company to be liquidated. So the court simply assesses these reasons presented by the petitioner. Are they valid for the court to give out a liquidation order for the company to end its life? So that's basically what will happen. So there has to be a petitioner who comes to the court. That petitioner comes with the reasons as to why he wants the company to be liquidated. So once the court assesses the reasons and the court sees they're actually valid reasons that can lead to a compulsory liquidation, that's when now the court will give out a liquidation order. So that's basically once the liquidation order is actually now given, now the liquidation process actually commences. So what are the reasons what are the reasons that can actually basically, so this one is basically liquidation that is normally done by the court or compulsorily by the court. So what are the reasons for compulsory liquidation? What are the reasons for compulsory liquidation? So part of the reasons that can actually lead to compulsory liquidation, that can actually lead to compulsory liquidation is, for example, number one, if the company is operating, without meeting the statutory requirements, with regard to membership, For example, in this case, if it is a public company, we say that it must have at least 2 members and there is no maximum limit. So if it has been operating without meeting the statutory requirements, for example, with only 1 member, then it can actually be compulsorily liquidated. Then another reason is number 2, if the company has passed a special resolution that the company be liquidated by the courts. So they could basically meet as members and basically agree that the court should actually give out an order or a liquidation order that the company life be ended compulsorily. So through a special resolution by the members of the company. So through a special resolution by the members of the company, So the company can also be compulsorily liquidated due to, so through a special resolution by the members of the company,
I have a question, Malim.
Yes, you can ask.
I was going through some questions and there's a question asking,
Yes.
outline 4 grounds upon which the liquidator might resign in a member's voluntary liquidation.
Grounds upon which a liquidator might resign
in a member's voluntary liquidation.
Grounds upon which a liquidator might resign. So this one is actually basically under a voluntary liquidation. So maybe what could actually make this particular liquidator to resign, one of them obviously is maybe due to maybe frustration. So he has not actually been given the required support by the appointing authority, or basically the appointing parties. So for example, in the case of voluntary liquidation by members, they are the ones who will basically appoint him as a liquidator. And of course, they'll set out what will be his duties and powers. And of course, set out what will be his remuneration. So part of the reasons that can actually basically make this particular liquidator to be able to resign is, for example, failure to get cooperation or support from the members of the company. So if they are basically failing to cooperate with this particular liquidator, he might end up actually being frustrated and actually basically end up resigning as the liquidator of the company. Another reason is it could be, for example, if it is discovered that he's not actually qualified as basically a person who can actually basically be as an insolvency practitioner, because basically they look for an insolvency practitioner. So you might find maybe his certificate of practice as an insolvency practitioner has actually been revoked. So he no longer basically qualifies to serve as the liquidator of the company, So we've said failure to get cooperation from the members. If his qualification has actually been disqualified as maybe an insolvency practitioner, so he can voluntarily resign from actually being the liquidator of the company. So those are the two I can be able to get at this particular point. So I think I'll get the others reasons as to why can actually make this particular liquidator under voluntary liquidation by members to be able to resign. So maybe we can wind up with the reasons as to why compulsory liquidation can actually happen. So we have said through a special. Yes, you have a question.
Under that question, the grounds under which the liquidator may resign.
Yes.
Can we talk of maybe conflict of interest?
Yes, that is actually a point. So there could be a conflict of interest. For example, if in this case, that particular liquidator has an interest has arisen in the company. So maybe it is discovered that, for example, maybe a next of kin of this particular liquidator has a particular interest in the company. So maybe there could be a discovery that maybe this particular liquidator can actually be able to favor that next of kin. So that is actually a valid point you can actually be able to put there. So if it's discovered that there can actually be what we call conflict of interest with regard to that particular liquidator having an interest in the company, maybe directly or indirectly. So is a point you can actually also be able to add there.
And also maybe we can talk of unsoundness of the mind.
Unsoundness of the mind. It's a valid point. For example, in this case, your thinking capacity is not actually proper. So you could not actually be able to execute your mandate properly. So in that case, it simply means that you are not actually able to execute your role properly. So unsoundness of the mind, or basically if you are declared to be insane, so you can basically ask to be relieved of the duties, or maybe due to any other reasons. So it could maybe not even be unsoundness of the mind. So maybe sickness. So you are maybe away for a very long time, so you cannot actually go to execute your mandate properly. So you can voluntarily resign so that you don't remain as a burden or a person who's not actually able to fulfill the mandate you've been given by the members of the company, So those are some of the points you can actually be able to add there. Yes, so reasons. So we've said through a special resolution by the members of the company, if the company is operating without meeting the statutory requirements with regard to membership. So failure to basically operate as per the requirements of how many members are supposed to be members of the company. So another reason it could be where the company fails to commence business, for example, within a period of 1 year after its formation, and there is no actually valid reason as to why the company has not actually been able to commence business. So number 3, where the company has failure to commence business within a period of a year, after formation without any valid reason. So basically you have no valid reason. It could be one of the reasons that can actually make someone to go to the courts and ask the company be liquidated. Another reason, it could be if the company fails to meet its obligations. So if the company has failed to meet its monetary obligations or payment of its liabilities, for example, loans. So that could actually basically be a signal to someone to petition the courts. So if the company has failed to meet its monetary obligations or payment of its liabilities, so it could actually be another reason. So other reasons, they are normally categorized under just and equitable grounds. So basically to execute justice, those reasons basically will lead to the company being compulsorily liquidated. So the court assesses the circumstances in place. And if those particular circumstances are actually in place under just and equitable grounds, or for the court to ensure it is basically ensuring justice in the operation of the company, it will recommend the company be liquidated. So we have number 5, just and equitable grounds, under just and equitable grounds, under just and equitable grounds. So these ones are usually many. So just from the word just and equity, to ensure equity and justice in their company, these reasons that we are going to talk about will make the court to declare that the company be compulsorily liquidated. So number 1 is failure of the main objective as to why the company was actually formed. Failure of the main objective, why the company, as to why the company was formed. So if that objective has not actually been met, so the company could actually be liquidated. So failure of the main objective, why the company was formed, why the company was formed. Sometimes we normally say failure of the substratum, substratum. But if you just say failure of the main objective, you are good to go, you're at home. Another reason, it could be deadlock in management. If there's deadlock in management, or the management cannot see eye to eye, deadlock in management. So it could be another reason that could actually make the court to see that for justice to prevail in the company should just be liquidated. Because how do you meet as directors of the company, yet you cannot see eye to eye? Is there anything you can discuss with regard to management or operation of the company? So there's no way you are going to meet. So the company will basically be stagnated. So if there's deadlock in management, where there is actually deadlock, or basically complete deadlock in management of the company, Another reason, it could be if the company is making losses, if the company is consistently making losses, if the company is consistently making losses and there are no chances it will be profitable, and there are no chances it will be profitable. So the losses are just consistent. So each and every year it's a loss. So it simply means that that could be a reason that can actually make someone to go to court. So there are no chances it will actually be a profitable company. Another reason, it could be where there is what we call exclusion in the management. Someone is actually being excluded to take part in the management of the company. Exclusion in the management of the company. So someone is excluded from actually taking part in the management of the company. Another reason, it could be where the company is carrying on illegal business. The company is carrying on illegal business activities. So illegal business activities. So if the company is being involved in business activities which are actually outlawed, it simply means that the company can be liquidated under just and equitable grounds. So we've said failure of the main objective, deadlock in management, if the company is consistently making losses and there are no chances to actually be profitable, where there is actually exclusion in the management, where there is exclusion in the management of the company, where the company is actually carrying on illegal business activities, where the affairs of the company, so we can add another one, where the affairs of the company are being carried on, in a manner which is unfair. So where the activities of the company or the affairs of the company, where the affairs of the company, where the affairs of the company are being carried on, in a manner which is unfair, to the minority members. So those who have small shares, minority members or shareholders. So these ones, they don't have a lot of powers or a lot of voting rights, but the way the company is being carried out is actually very unfair to them. So they could actually basically petition the court, go to the court and of course petition and ask that the company be liquidated compulsorily by the court. So if basically you present these reasons, the court will look into them, see whether they are making sense. Are they reasonable for the company to liquidate the company, the court to liquidate the company or give out a liquidation order? So these are the reasons that a petitioner can go to court with. So they'll basically assess them. So you can choose one of them and basically present to the court and argue as to why you want the company to be liquidated under that particular reason or ground. So if the court sees its validity, then of course they can actually be able to give out a liquidation order. So who can petition? Who are the petitioners? Who are the persons who can basically go with this particular evidence to the court? So you can have, for example, members of the company or the company itself. You can have creditors. We can have the attorney general. And of course, you can have the official receiver, or we can have the provisional liquidator. So the parties who can petition or basically can present this particular evidence to the courts include, so they could ask who are the petitioners who can basically petition. So who can petition? Who can petition? Who can go to the court with this evidence or these reasons we've just talked about? Because we've said what must actually happen before the liquidation order comes, there must be a petitioner who has gone to the court. So we can have the company itself. So we can have the company itself through a special resolution. So you can have the company. So you can have the company. Number two, you can have a member of the company, Number three, you can have creditors. Number four, you can have the attorney general, or the AG. This is especially due to public interest. And then of course we can have the official receiver, or provisional liquidator, or you can just say the administrator of the company, the administrator. So these parties are the ones who can actually basically petition the courts or bring those reasons as basically they want the company to be liquidated. So you can have the company itself. When we talk about the company itself, through a special resolution. So they'll basically present that resolution. They'll simply basically clearly state in that particular resolution, at this particular date, we met as members of the company and decided that the company be liquidated by an order of the court. The reasons as to why we want the company to be liquidated are these ones, 1, 2, 3, and of course they present to the court. So the court looks at them and of course basically now gives out the liquidation order, the liquidation order. So those are basically the parties who can petition. So they could ask in the exam, who can petition for compulsory liquidation of the company? Alternatively, they could ask, what are the just and equitable grounds under which the courts can issue a liquidation order or can declare the company be liquidated? So they like this one, so they could ask under just and equitable grounds. So if they ask just and equitable grounds, mention the ones we've just mentioned under just and equitable grounds. So if they ask for the petitioners who can petition, remember the company, remember a member of the company, remember creditors can also call petition. Attorney General, especially this one is normally due to public interest. So maybe there have been a lot of complaints in a particular area that a particular company is carrying on illegal business activities. It is basically manufacturing drugs which are actually outlawed. So in such a case, the Attorney General, basically due to public interest, he petitions the court and brings the reasons forth to the court as to why he wants the company to be compulsorily liquidated. The official receiver, after carrying out the receivership process, he discovers that this particular company cannot actually come back on track. He basically gives out a report to the court that appointed him as a receiver, that of course the company can actually be liquidated. So the court will give out a liquidation order. So those are the petitioners. So we can look at what basically happens after the court has actually been able to carry out or give out the liquidation order. So when the court has done the assessments, they'll give out a liquidation order. That liquidation order will basically come with the appointment of a provisional liquidator. So they'll appoint a liquidator through the liquidation order. So they'll clearly indicate, we've given out a liquidation order and we've appointed party A, B, C to be the provisional liquidator of the company. So the provisional liquidator will simply come into the company and of course ask for all the accounts, statement of accounts or statement of affairs of all the assets and liabilities of the company. So that is what will actually happen when that particular provisional liquidator is actually appointed. So the liquidation order, basically, one of the things that actually happens with the liquidation order, or the consequences of the liquidation order. So what are the consequences? Consequences of liquidation order by the court. Liquidation order by the court. Liquidation order by the court. So what are the repercussions when that liquidation order has been given by the court? So the consequence that will actually arise, number one, it will serve as a discharge. It will serve as a discharge of all the officers of the company. Unless they are required for the beneficial liquidation of the company, So you can see what actually happens, that when the court gives out the liquidation order, everyone loses his position in the company, unless they are basically required to be maintained or retained. The employees are required to be retained for the beneficial liquidation of the company. Number two, the powers of the board of directors are terminated. Powers of the board of directors are terminated. So their powers will actually automatically be terminated. The powers of the board will actually be terminated and will be exercised by the provisional liquidator, and will be exercised by the provisional liquidator. So automatically, the board of directors lose their position, and of course, sasa wakusema kwa kampuni atakuwa huyu jamaa ambaye ameappointiwa na court. So board wata lose their positions automatically. So they lose their positions automatically, and their powers will basically be vested in the provisional liquidator. The next one, the order will operate in favor of all the creditors. The order. So wale watatetewa sana after that, will basically be the creditors. So they are usually very safeguarded during this particular process. So they'll basically be put together. They discover how much the company owes them. They are supposed to be paid. So the order will basically operate in favor of all the creditors. So the order will operate in favor of all the creditors, in favor of all the creditors, whether secured or unsecured, in favor of all the creditors. So the order will operate in favor of all the creditors of the company, in favor of all the creditors of the company. So another thing is that no legal proceedings can commence against the company without the permission of the court. So in case you want to bring any suit against the company after the liquidation order has been given, you have to seek permission from the court. So you don't just basically sue the company without having sought the permission of the court. So no legal proceedings can commence against the company without the permission of the court. So number 4, no legal proceedings can commence against the company, against the company without the permission of the court, without the permission of the court. So the court has to permit anyone who wants to basically commence any legal proceedings against the company. So then another thing is that the court will have powers after that to dispose of any proceedings against the company. So if there was actually any case against the company that was actually ongoing, that was actually in a court of law, then they give out a liquidation order. After the liquidation order, the court will actually have powers to basically dispose of, or maybe decide that they are going to continue with such proceedings. So the court will have the power to dispose of any proceedings. Court will have the power to dispose of or continue with any proceedings, against the company, So they can decide which cases are going basically to remain active against the company, or which ones are going to be done away with, or which are going to be disposed of when the company is actually under liquidation, Then another thing is that the official receiver, or basically the receiver, if there was actually a receiver, he'll basically assume the role of a provisional liquidator. So the official receiver assumes the position of a provisional liquidator, If there was no any receiver in such a case, the court will actually appoint this particular provisional liquidator. So they'll appoint one through the liquidation order. But if there was actually an official receiver who basically recommended the company be liquidated, he will assume immediately the position of a provisional liquidator. So these are the consequences that will basically arise after the court has declared that the company should actually be liquidated, So once the liquidator has been appointed, what will actually happen? The liquidator, once is actually appointed by the court, the provisional liquidator, when he comes into the company, as we've said, he'll basically gather or basically get the statement of affairs of the company that basically lists as to what are the assets and the liabilities all put together for the company. So he must actually be able to compile this particular report within a period of, let's say, for example, 2 weeks or maybe 14 days. So after that, he'll basically convene a meeting of the creditors and the members of the company. So from the creditors and members of the company, he will come up with what we call a liquidation committee. So you've seen what happened. The liquidation order has actually appointed the provisional liquidator. So now he's been given the mandate to go ahead and actually start the liquidation process in the company. The first thing, gather the statement of affairs of the company, basically which actually lists as to what are the assets and what are the liabilities of the company. After that, he basically convenes a meeting of the key stakeholders of the company. Who are they? They are members and creditors of the company. Out of these, he'll basically constitute a liquidation committee. So he'll come up with a liquidation committee. So part of the roles or the function of the committee will now basically to now officially appoint a liquidator. Remember, he's actually just a provisional liquidator, the one that the court recommended. But now, of course, the company stakeholders are the ones who are supposed to take out full responsibility in terms of the liquidation of the company. So he convenes the meeting of these particular key parties in the company. Then they come up with a liquidation committee among them. So let's say, for example, they choose 3 creditors and, of course, 3 members of the company. So after the liquidation committee has been formed, this particular liquidation committee, part of the roles or duties will include, for example, now to formally appoint the provisional liquidator as the liquidator of the company. Number 2 is, for example, to set out what will be his duties and roles as the liquidator of the company. So another thing is, for example, now to set out the remuneration. So that camera has gone off. They'll set out the remuneration of the liquidator as to how much he'll actually be compensated or be paid as a liquidator of the company. Another duty will include, for example, to monitor or, for example, check as to what is the progress in terms of the liquidation process of the company. How far has the liquidator actually been able to carry out the liquidation? How much has he actually been able to pay off as liabilities or maybe amounts to creditors? So basically monitor the liquidation process and basically supervise the liquidation process. So this particular liquidator will simply be reporting to the liquidation committee as to how far he has carried out the liquidation process. So those will be part of the duties and functions of this committee we are calling the liquidation committee. So appoint the liquidator officially or formally, set out what will be his roles and duties, monitor the liquidation process, set out what will be the remuneration of the liquidator of the company. So those are some of the functions or duties of the liquidation committee that will be set up by the provisional liquidator. That will be set up by the provisional liquidator. So apart from the duties that are set out by this particular person we are calling, or the duties that are set up by this particular committee we are calling the liquidation committee, there are those powers or mandates that come with the liquidation order or come from the courts. So automatically those ones are actually basically...
There's someone who is requesting to be let in.
So I think I've already let her in. Is it Edna? I think it should be Edna. It's the one I was seeing was actually out. But I think she has gotten in. She has gotten.
Yes.
She has gotten
Thank
in.
you.
It's okay. So it was actually Edna. So we can look at the powers that will come with that particular court order, or the powers that will be derived from the court. So you can look at them. So powers of the liquidator. So you can see powers through the court sanction or the court order that basically is actually giving out an order for the company to be liquidated. So they are basically listed in your notes. So number 1 is to institute or defend any suit in the name of and on behalf of the company. So for example, if there's actually any suit against the company, he will basically be the one who will be standing in on behalf of the company. So he'll be the one who will actually basically be standing in to represent the company, because he's the one who will actually basically be carrying out the affairs or basically managing the affairs of the company. to carry on the business of the company so far as may be necessary for the beneficial winding up of the company. So as we've said, when the company has been liquidated, sometimes the employees can actually be retained for the beneficial liquidation of the company. Maybe the company can remain in existence to basically liquidate the inventories. So these goods that are actually basically in the company as inventories or goods that are supposed to be sold, they can basically sell all of them before the company actually ends its life. So they can basically retain the employees who are actually involved in selling the products until when they're actually basically depleted or actually completed. So they liquidate the inventories. So his role will actually basically include, for example, to ensure the company is actually carrying on its business activities for the beneficial winding up of the company. Because if they liquidate the inventories, which are actually assets, they'll get actually enough money to be able to pay off the liabilities. Number 3, to raise any money as may be required and charge the company's assets. So you can actually basically look for ways of how you can raise money to be able to pay off the liabilities, maybe by charging the assets during the liquidation process. Appoint an advocate, for example, in case there's actually any court proceedings, and basically he wants to basically someone to be able to represent him as an advocate or advise him on legal matters. To pay any class of creditors in full or make compromises or arrangements with such creditors. So part of the roles of a liquidator is to pay off the liabilities, among them creditors, according to their priority, or basically how they're ranked according to their priority. To compromise calls, debts, and other pecuniary liabilities with contributories or debtors. So enter into compromises or maybe with some of the debtors or basically some of the contributories. So they agree how basically they can actually be able to pay off their due amount to the company. So the debtors of the company. To do all such other things as may be necessary for the winding up of the affairs of the company. So affairs of the company and distributing its assets, e.g. setting a list or basically settling the list of contributories and creditors. So contributors are simply owners or members of the company who are actually entitled to the residues of the company after they have paid all the creditors and liabilities. So duties of the liquidator without the court sanction. So these ones don't come with the court sanction. So they are obviously assumed by the liquidator without the court sanction. So these ones will basically be named or actually outlined in the court sanction. So these ones are actually basically automatic. So they are basically expected to be carried out by the liquidator once he's actually appointed as a liquidator. To conduct the liquidation proceedings and perform such duties as the court may impose. To submit preliminary reports to the court after the receipt of the statement of affairs. To take into custody all the books and documents and assets of the company. To give regard to the resolutions of creditors or contributories to any direction given by the liquidation committee. To summon meeting of creditors and contributories anytime he feels so. To maintain proper books in the prescribed manner to record entries and minutes of proceedings at meetings and such other matters as may be prescribed. Any member or creditor may be allowed to inspect such records. To present an account of receipts and payments to the court, which then gets the accounts audited, keeps one copy of the audited accounts and delivers to the other copy to the registrar of companies. Then to submit information concerning any pending liquidation where the process is not actually concluded within a period of 1 year. So what happens is that the liquidator will actually give a report each and every year. So after the year elapses 12 months, he has to give a report. If the liquidation process has taken, for example, let's say, for example, 3 years, it simply means he'll actually be able to give like 3 reports. So sometimes it can take a very long period of time before the liquidation process actually comes to an end. So, for example, in this case, Imperial Bank is actually under liquidation. So it has been under liquidation for quite some time. It has not actually fully been liquidated. So it is normally a process that can actually take a number of years. So each and every year, he has to give a report or a liquidation report. So that is basically what you need to be able to understand under what you are calling compulsory liquidation or liquidation by the court, or liquidation by the court. So the last bit you are supposed to look at is what we call voluntary liquidation. Voluntary liquidation. Voluntary liquidation. So we can look at voluntary liquidation. So this is where the company voluntarily decides it is going to be liquidated. So it is liquidated voluntarily without having been to be forced by any person. So no one goes to the court. The company just voluntarily decides it is going to be liquidated. So it can actually be voluntarily liquidated by the members of the company. So by members, or it can actually voluntarily be liquidated by the creditors of, the company, by creditors of the company. So the company can voluntarily be liquidated, for example, if the objective as to why it was actually formed has already been met. So they no longer have to be in existence anymore. For example, maybe it was actually basically formed to fulfill a certain project. It has already been fulfilled. So there's no need for basically this particular company to continue to be in existence. So some of the reasons can actually make a company to be voluntarily liquidated. For example, if it has already met the objective as to why it was actually formed. So it has fulfilled that particular objective. So there's no need for basically the company to continue to exist. So it can actually voluntarily be liquidated, or its life can voluntarily be ended. So it can be liquidated either by members or by creditors. So the way of how it will be liquidated voluntarily depends with whether this particular company is actually solvent or insolvent. And of course, whether it is actually solvent or insolvent will basically be determined by the board of directors. So it has to be determined first whether the company is actually solvent or insolvent. Once this has been determined, then now it can be chosen as to whether it can be voluntarily be liquidated by members or by creditors. So there will be the declaration as to whether the company is solvent or insolvent by the board of directors. So that is what actually normally happens first. So it has to be determined as to whether the company is actually solvent or insolvent by the board of directors. What we mean by solvent, so now we can go to what is solvent and insolvent. What we mean by solvent simply means that the company can be able to meet its obligations in the short term. It can actually be able to pay off all its liabilities in the short term, the shortest time possible. That is basically not more than 12 months or not more than a year. It will actually be able to meet off or pay off all its liability. It simply means that the company, for example, it is actually very liquid. It has a lot of money to be able to pay off all its liabilities. So there'll be that particular declaration as to whether it is actually able to meet its obligations within the shortest time possible, or whether it is not actually basically liquid enough to pay off its liabilities within the shortest time possible. That is basically more than 12 months. So that means it is actually insolvent. If it is insolvent, it simply means that the company is not actually able to pay off or meet its obligations within the shortest time possible. So it can only be able to do so for more than 12 months. Let's say, for example, 16 months or maybe 2 years. So there'll be that particular declaration by the board of directors as to whether it can either meet its obligations in the short term or maybe meet its obligations in the long term. If it is actually in the short term, it simply means that the company is actually very solvent. Ikona chapa. If it is actually insolvent, haina chapa, imesota. So it can't actually be able to pay off its liabilities very quickly in the shortest time possible. If it is solvent, ikona chapa, the company will opt to go for voluntary liquidation by members. If it is insolvent, haina chapa, imesota, the company will go for voluntary liquidation by creditors. So wale watu wa madeni watakuwa involved. That is the creditors. So if the company is insolvent, the company will go for voluntary liquidation by members. If the company is insolvent, they'll have to involve the creditors. So it'll go for voluntary liquidation by creditors. So that's basically what we mean by voluntary liquidation by members and by creditors. So it's simply whereby there's the declaration as to whether the company is solvent or insolvent by the board of directors. Once that has been determined, then now the company can either choose to go for voluntary liquidation by members or by creditors. And of course, I've already explained what is actually solvent and what is actually mean by insolvent. So if it is being liquidated by members, in this case, what will happen, the members will actually convene a meeting in the company and of course, appoint a liquidator. So they'll appoint a liquidator and set out what will be his duties and roles as the liquidator of the company. Also, they'll set what will be his remuneration. And of course, basically they'll act as the supervisors of the liquidation process. Remember, under compulsory, there was a liquidation committee. In this case, the parties who are basically liquidating the company are the ones who appoint the liquidator. The same way, if it is being liquidated by the creditors, they'll convene a meeting in the company and appoint who will be the liquidator. They'll set out what will be his duties, set out what will be his remuneration. And of course, this liquidator will actually be reporting to the creditors because they're the ones who actually appointed him as the liquidator of the company. If they are the members, also the liquidator will actually be reporting to the members of the company. So in this case, each and every time, if this particular liquidation has taken more than a year, of course, in this case, it simply means that it is by creditors. He has to give a report at the end of each and every 12 months to the creditors who actually appointed him as the liquidator. Once the liquidation process has actually come to an end, this liquidator will give out what we call a liquidation report. So this report will be given to the creditors or either the members. Then, of course, it will actually also be deposited at the register of companies. So once that has actually been done, the register will basically assess it and, of course, dissolve the company, dissolve the company, dissolve the company, dissolve the company. So that is basically what you need to be able to know about voluntary liquidation, voluntary liquidation. And actually that is the end of this particular topic, receivership and liquidation of companies. So what is just remaining maybe is to look at some past paper questions with regard to this particular topic. But of course, that is voluntary liquidation of a company, voluntary liquidation of a company, So there's a topic we are remaining with. You've looked at, so we are remaining with foreign companies or companies incorporated outside Kenya. Then we are remaining with the auditors, then accounts, and investigations. Very short topics. So I'm hoping we'll be able to do all of them in our next class. So they are not that long, so they are a bit shorter. Even this one is a bit longer. This liquidation is actually a bit longer. This one's actually very short. So I think we'll go through them in our next class. And I think we'll call it as syllabus coverage. So I think the other class after that, it will be revision. It will be revision. So because our next class is actually on Sunday, so hopefully I'll be able to make it. I might be out of town, but I'll see what to do. I might be out of town, but I'll try not to miss that particular class because I really intend next week we start revision. So next week, basically that means on Wednesday next week we start revision. So that is on 1st. So exactly on 1st we should start revision and do first. We'll do like maybe 4 classes before the exam. 4 classes before the exam. We do like 4 classes before the exam. We do revision because the exam is actually around 15th, 16th there. So we'll have like 2 weeks for revision. 2 weeks for revision. So I'm hoping on Sunday I'll be able to make it and we wind up with the syllabus. Yes, someone has a question there.
Explain for instances when the release of a liquidator becomes effective.
When the Release of the liquidator
becomes effective.
Explain 4
instances when the release of
liquidator becomes effective. When release of the liquidator becomes effective. So, for example, we could talk about when he voluntarily resigns, and the resignation is actually accepted, by the appointing parties. So that could be the liquidation committee, or maybe the members, or the creditors. Another one we could actually be able to talk about after submitting the liquidation report, to the registrar, and the company is dissolved. Another one we can actually be able to talk about in case of appointments, of another liquidator to replace him as the liquidator. Another one could actually be able to talk about whereby he has been removed, as a liquidator by the members or creditors, So where he voluntarily resigns to submit the liquidation report and the company is completely dissolved. So he has finished actually his mandate. In case of appointment of another liquidator to replace him, where he has been removed as the liquidator by the members or creditors who actually appointed him as the liquidator of the company. So we could talk about those particular reasons. Yes, and any other question, you can ask 1 or 2 questions. Time has really gone. So you can ask 1 or 2 questions. So we'll see whether we can actually be able to finish up in our next class these small topics. Then we see how we'll start revision coming week. But as I told you, don't panic. Just revise, relax, revise what you've been learning in the class. Then when the time to exam comes, you confidently walk into the exam room. If you've been in class, you don't have to worry that the exam will be difficult. You confidently walk into the exam room without having to panic and sit for the exam confidently. You'll pass. You don't have to panic. Just continue revising consistently what the teachers are teaching in the class. Then at the time the exam comes, you confidently walk into the exam room without any panic. And of course, sit for the exam paper. You will pass. So you can have a good night. We'll meet probably on Sunday. We'll meet on Sunday and see if you can wind up with the syllabus and start revision.